Okay, then this is People of the State of Michigan versus Deandra Lane, docket number 19-832FH. This is the time set for sentencing. And Mr. Lane, if you could just confirm for me again, I think I asked you before, but you're okay with doing the sentencing without you being in the courtroom, is that right?
Yes, ma'am.
Thank you. And Mr. Lane, you were convicted of possession with intent to deliver less than 50 grams of cocaine. That is a felony punishable by up to 20 years in prison. You have the right to an attorney, and you are represented by Mr. Shepard. Mr. Shepard, have you had a chance to review the pre-sentence report with your client?
Yes, I have, Your Honor.
Do you have any additions, deletions, or corrections?
Yeah, some brief additions, Your Honor, and corrections. The first one is that I am retained counsel on this case on the face sheet of the report, and then it's listed on page 1 under evaluation and plan. It just listed me as public defender or appointed, and that's incorrect. It should be changed to retained.
Mm-hmm. And it's probably on the BIR as well.
It may be.
Yes. Okay, I changed it in all those places.
All right, thank you, Your Honor. And then additionally, the court does not have my client's correct and updated address, and I can give that to the court now if the court wishes.
Okay, is it not the one on the BIR?
Let me just make sure, because they attached and stapled the 2018 report
Yep.
to this one.
Yep. Well, take a look at the BIR for our report, not the previous one. Of course, actually, it's the same address. On Viola?
Yeah, that's incorrect, Your Honor.
Okay, can you give me the right one?
Yeah, it's 2506 Greenbelt, Greenbelt, all one word. And that's Lansing, Michigan, 48911.
Okay, thank you. And your next one?
And the other change, Your Honor, is that because they just, again, attached the old report from the 2018 report, my client is actually married, and his wife is, I can just spell the name for it if you want.
Well, hold on, because I don't think I can really change the previous report, and that's probably the only place it appears, correct? Or
Well,
no?
I just wanted the court to have the information, but I think that's right that it does have that on there. In the old
although
report.
It might be. Okay, so on our report under evaluation and plan, the third paragraph, it says 32-year-old single male. I'm gonna change single to married.
Yes, Your Honor.
And then you want to give me his wife's information? Or
Yeah,
whatever
her
you
name. Yep. Did you change your last name? Yeah. Okay. So her name is Lajamia. It's Lajamia.
Okay,
And then last name Lane.
okay. Thank you. Next change?
I think that's all as far as the additions, corrections, or deletions, Your Honor. I mean, he is currently unemployed. He'll be starting back in January 2021, but I guess that's more for elocution.
Right. Any objection to the scoring of the guidelines?
No objection, Your Honor.
All right, did the people have any corrections to the report or objections to scoring?
No, Your Honor.
And did the people wish to be heard?
Only to say, Your Honor, I've spoken with Ms. Spears throughout this event. She's the homeowner of the apartment where this all kind of ended up. And she was happy with the resolution on this case. So the plea restitution is important to her, and she has a lot of personal loss going on right now in her life. So she's happy for this to be over and happy that he took responsibility for the issues that he has and hopes that he gets help through those. Thank you.
Okay, thank you. And now you, Mr. Shepherd?
Yes, thank you, Your Honor. Your Honor, I've known Mr. Lane now for a pretty significant period of time, and some of that relates to COVID-19 and the pandemic and just the passage of time that this case has gone on in the circuit court for your case. But I also represented Mr. Lane in the Eaton County proceedings. I didn't represent him at the time of sentencing, but anything post-judgment, I did represent Mr. Lane. And I just want the court to be aware and to know, as far as some of the history of that proceeding, is that the reason why he was before that court on probation violations was because of this conduct. But then in addition to that, he also had tested positive for cocaine. And so the conduct prior to that time, he had no violations and he was compliant with probation. He was doing well and he was complying and doing the classes, doing the things that he needed to do. He had paid off all the fines and costs, and we basically came to an agreement and resolution with the prosecutor there and with Judge Cunningham that because Judge Cunningham, through my, representations to her, we thought that this case would likely resolve in some way that would ultimately end up placing Mr. Lane on probation. And Judge Cunningham knew that too. And she, decided that she didn't want to keep him on probation. So while she did, end his probation, and it is listed on the paperwork as an unsuccessful completion of probation, it was all done in coordination and knowing that he was going to have some sort of pathway to rehabilitation through this court. And that's why Judge Cunningham didn't continue him on, because I think she otherwise would have. It wasn't you failed out. We've taken all that we can do, and we've come to our end here. It was a type of situation where she knew that there was going to be some additional rehabilitative efforts for my client, and that's why she did what she did. He did the 30 days jail, and he actually got out right as the pandemic hit, and life changed for everyone. But in reading through this report, Your Honor, and in looking at my client's he was full-time employed before the pandemic. He has 6 children, 5 of which are in virtual learning, and he has, chosen to continue to be not going back to work full-time because he assists and helps in the virtual learning for 5 of those 6 kids. He does take care of his family. Again, he's been, working and does have a good, successful work history with DTN. That's where he's going to go back to work in January 2021. And so my client does have a lot of good positive attributes, but certainly the negative attributes for him are a drug addiction and history of substance abuse, and then obviously the legal troubles and legal concerns that he's gotten into. I think that the report in this case is consistent with the fact that my client, he's not some kind of, big drug dealer or big, gangbanger kind of guy, but it is consistent with drug use and a history of addiction. But he's also, I think it's also consistent with the fact that my client played a very limited role in terms of the home invasion situation that was going on here. And basically he knew who was there. He knew who was present. But he's taking responsibility in terms of financially for the restitution amount that is owed to Ms. Spears. He's willing to do that, and I know that he'll pay that down and he'll get that paid off as far as the restitution amount. But I do think that rehabilitative efforts are in place here, and we have the Cobb's agreement that I'm hoping the court will follow and abide by in terms of no further upfront jail. But the only issue that I have, Your Honor, as far as is the TRICAP program, because I guess I didn't fully familiarize myself with that program, but if it's an inpatient facility, then I don't think that that's the right starting point for my client. I think that outpatient services are more appropriate. I do think testing and monitoring and some sort of drug rehabilitation type services are appropriate, but I think they should be through an outpatient services. I think myself personally, in my experience with clients, is that sometimes if you don't have the type of addiction that really requires immediacy of a program like inpatient, then you actually can go in and you can, somewhat learn bad habits and be around some bad people and actually make things a little bit worse for somebody that may not otherwise be in that position. And so I think that, again, like intensive type outpatient or outpatient services of some sort are more appropriate. Monitoring in terms of drug use and testing and all that goes along with that as far as probationary status is much more appropriate for my client. Again, he's out in the community, he's taking care of his family, he's married, he's got long-term stability of relationship right now and stability of residency. And so I think that's the best thing for my client, Your Honor. But I just wanted to let the court know a little bit more about the background in terms of his situation. And if my client wishes the same thing on his own behalf, he can do so.
Of course. And Mr. Lane, is there anything you wanted to say?
No, ma'am.
Okay. Well, I agree with a lot of what your attorney said, including that you have some good attributes: a stable home, responsibility towards your family, hopefully employment picking up again in January. There are good things. I did say, as part of a Cobb's agreement, no additional upfront jail. I'm going to go along with that. I would say, however, I wish you were a little more upfront in responsibility taking on your behavior. I don't think it was all that great according to what I read in the pre-sentence report. And I have to disagree with your lawyer because the previous report in front of Judge Cunningham indeed sounded as if you were selling drugs. But whatever the problem may be, and maybe it's more use than anything else, I don't know. I think that the structure of probation would be beneficial for you, and I can that way ensure that you not only comply with all the conditions, but that you also are tested and monitored for any potential drug use, and we can address it if there is a problem. And of course, if there is a problem, if it's significant enough, the Cobb's agreement of no further upfront jail is just for today. So, I'll deal with it as I see fit. And I'm not saying necessarily jail, but what I'm getting at is inpatient might be what's called for. I'm not going to do that now because I think in the spirit of things it would conflict with what I said, which is no further incarceration and any inpatient treatment. Realistically, Mr. Shepard, I'd be remanding your client, and so I'm going to stay true to my agreement and not do that. I am going to place you on probation for a period of 18 months, 2 days in jail with credit for 2 days served. You have to pay $130 to the Crime Victims Fund, $68 in state costs, oversight fees in the amount of $180 payable at the rate of $10 a month, restitution in the amount of $1,170 to Dolores Spears, costs in the amount of $500 based on the State Court Administrative Office calculated average cost for criminal case in Ingham County. Additional conditions of probation are no use or possession of alcoholic beverages, controlled substances, drug paraphernalia, or medical marijuana. Comply with both drug and alcohol testing as your agent directs. Complete a substance abuse assessment when you're referred by your agent. Complete outpatient or residential substance abuse treatment as your agent refers you. You must complete any mental health treatment following assessment that you are referred to. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. No contact with anyone you know to have a felony record. You must not change your residence unless you first get written permission from your agent. You may not possess a weapon while you're on probation. You must allow the agent into your home at any time, submit to a search of your person or property without need of a warrant, report any changes to your agent within 24 hours, be in your approved residence between the hours of 10 p.m. and 6 a.m. unless your agent approves a different schedule. You must not have any contact in any form with Dolores Spears or be within 500 feet of her residence, school, or place of employment. Your driver's license is suspended by law. You may not drive a motor vehicle while your license is suspended, and it's a 1-year suspension. And you must make genuine efforts to find and maintain employment a minimum of 30 hours per week. You have have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. We will mail the form to you that you do that with. It will explain more about it. You should just know that mail is slow, and the 42 days to start your appeal starts running from today. And then also, Mr. Lane, you're advised that you need to contact probation, the probation department, right away. So I'm sure Mr. Shepherd can give you the phone number to call, but within 24 hours, make contact with the probation department. They're not seeing people in person, so you'll need to call them up and tell them you've just been placed on probation, and they'll go through an orientation with you and give you a probation order. Okay, do you have any questions?
No, nothing right now, Your Honor.
All right, then that will conclude our